welcome to Law and Life Matters podcast. My name is Wathint'abafazi and I am your host today. Today we have the honor of having Thokwadi Seabela join us today. Hi Thokwadi, how are you?
Hi, Wathint'abafazi. I'm good. How are you?
I'm very well, thank you. Thank you so much for being here with us today.
Thank you for having me. I appreciate and I'm honored by the invite.
No, it's our pleasure. Just to introduce everyone to Thokwadi. Thokwadi obtained her BCom law degree and LLB degree from the University of Johannesburg in 2011 and 2013, respectively. She completed her practical legal training at the University of Limpopo's School for Legal Practice in 2014, where she received numerous accolades for her outstanding performance that year. Thokwadi joined MBA Incorporated as a candidate attorney in September 2014 and was admitted as an attorney of the High Court after completing her articles of clerkship in 2016. She was subsequently promoted to be an associate director at MBA Incorporated and served in that capacity from September 2016 to June 2017. In July 2017, Thokwadi joined a company in Rivonia as its head of legal and compliance. And during her tenure there, she developed policies and procedures for the company as well as its subsidiaries. She served on the board of directors of several subsidiaries and successfully represented the company in various forums such as the CCMA and relevant bargaining councils. She was also instrumental in negotiating acquisitions and the sale of shares between entities. Thokwadi returned to MBA Incorporated as an associate attorney in September 2018 and promoted to senior associate in May 2021. She now enjoys her new role as an associate partner. Thokwadi excelled in the disciplines of labor and employment law and dispute resolution. Thokwadi has appeared as a contributor and commentator on a variety of legal issues and mediums such as ENCA, SABC News, and Kaya FM. What a wow!
Hey, the mouthful. Is she speaking about me? Is it me?
No. We were speaking to the right person today. What a brilliant bio. How does it make you feel to hear that about yourself?
We last year we were at a work event. So you know how before we start the financial year ends, you usually have these work retreats.
Yes.
And we had a work retreat and we had this exercise that we were doing with our then CEO, Benjamin Gillies. And he had us do an exercise where we would pair up and then we would have the colleague that you had been paired up with then giving attributes, so describing you, what is their view of you, what is their description of you. And I remember I was paired with one of my colleagues, Nonhlanhla, and when we're sitting as a collective, as a group, and we're giving each other feedback and stuff like that, even as she was describing me and we're sitting, when we're sitting together in the pairs, I was like, is that me? Is that me? And even as a collective, I felt it very necessary to express to the group that it is so refreshing and so interesting to see yourself from the eyes of your colleagues, because you spend the majority of your time at the office. We are so immersed in each other's lives, so not just personally but even on a work level. So you get to the point where you realize that people recognize attributes about you that you don't readily recognize yourself. Our then CEO's comment was, well, it's important to know your worth. You as an individual should be able to recognize those attributes about you, but it still did not detract from the awe of and you could see the change and even the reflections amongst the group, that it's so refreshing to see yourself from other people, even when something is written about you. It's amazing. It's like, is that me? And because as human beings, it's so easy to detract from your achievements because we live in a very fast-paced environment. So it's very easy to not revel in the achievements that you've made, but you look at your journey and you look at the years and you realize that you're so blessed. God has been so good and so gracious throughout all the years. So I'm hoping to, achieve more in the little time that the Lord has given me here on this earth, and do more and be able to serve, more clients and more people, and, even people, serve my community as well, outside of my family and friends.
I think that's it. You're making a good point about the people we spend most of our time with, which is our colleagues, and just being able to talk about each other in that manner, and also to be able to receive it. And I think you're correct that we're not always able to receive it. And I hope not only will you allow yourself to receive it, but also own it. Own it. This is your work. This is your work.
That's true.
So, Thokwadi, what we really wanted to do with today is just focus on Thokwadi excels in the discipline of human law and dispute resolution. So what we really wanted to talk to you today about is just understanding dispute resolution. And maybe we can start off there. When we're talking about dispute resolution, what exactly is it that we're talking about?
I think that was I think even as a first question, that was a very interesting question for me. And I think it's because usually, when you think about dispute resolution, it's usually interlinked and intertwined with litigation. So you think about litigation and dispute resolution. But I've come to appreciate in practice that, dispute resolution is not just, when we think about dispute resolution, you think about litigating in a court of law, and there's a plaintiff and there's a defendant and there's an applicant and there's a respondent, and, you think about sparring in that sense. But it is such a wide field. And I think being in practice opens your eyes to the fact that outside of litigating, in court, there are so many other ways in which parties can resolve disputes. So even the word itself, dispute resolution, it speaks to how do we, the manner in which and how do we resolve disputes between parties. Because in any relationship, whether it is a relationship between a husband and a wife, whether it is a relationship between parents, and their children, whether it is a contractual relationship between two parties, whether it is a commercial relationship, there is always room, and I hate to say this, but there's always room for parties to differ and not be able to find each other. So there's always room for the lack of a better word, for a legal dispute to be created between the parties. But dispute resolution speaks to not just litigating, in a formal court of law before a judge, but it also refers to the broader scope of the manner in which we can resolve disputes. So you'll find, for example, in industries like construction and the engineering and built environment, you have, adjudication and arbitration. So even before a matter goes to court and it is heard by a judge, the parties are then obliged, in terms of either the contract, the JBCC they would have concluded, or the NEC, for example, to then find ways in which they can find each other. So there's different processes like adjudication, there's arbitration, but there's also mediation. So these are all subsets of the process of resolving disputes, because one always expects that by the time that there's an expectation that by the time we get to a court of law, and we are, filing pleadings, and there is a crossing of the swords, for the lack of a better word, that parties will have, availed and exercised and exhausted, these other dispute resolution processes. Because you'll find that a lot of times, if you go through an adjudication process where you appoint, an independent party to hear the dispute and adjudicate upon it, it will even negate the need for the parties to even end up in court. The same goes for arbitration and mediation, because you then have an independent party that is appointed to then essentially decide upon the dispute. And also because you have an opportunity to resolve the dispute, you as parties even have the opportunity to determine, you come to an agreement, and insofar as determining who's going to decide upon this this particular dispute that we have. How will we resolve this particular dispute that we have? So you'll find, for example, in arbitration, you can do in a mediation, you can decide to do like, you file a statement of claim, the other party will file a statement of defense, then the other party will file their replying document. And then you can even decide, is there a need, for oral evidence? Do we need people to come and testify in these proceedings? So it's just the process of, parties finding each other and resolving whatever issues may have arisen between them. And that's just for the purpose of then curtailing, the need for a litigious process in a formal court of law. And I think also the way that, our jurisprudence is, we have outside of a court of law, multiple disciplines of the law require disputes to be resolved in different ways. So that's why within a CCMA, dispute, for example, we're going to go to the CCMA at parties and we'll have a commissioner, for example, hear the dispute. So every industry has its, processes. But if we fail in the CCMA, for example, we'll end up at the labor court and the labor appeal court. So it's just a process where, parties can find each other and then negate the need for litigious process. But even if it goes to the litigious process, it still forms part and parcel of the process of resolving a dispute, because then you have another independent arbiter, another independent, judge or presiding officer, then hearing the dispute and then making a determination in respect of that particular dispute.
No, sure. I think you just made me understand that, because at its core, what you're saying is, and just help me out here, that you're saying that a dispute is obviously just the differences between people, between parties. So whether it's contractually, whether it's a family law type of thing, but it's just that differences. And what you're saying is what dispute resolution does, or what dispute resolution legal practitioners do, is say, what are our options? How do we sort out these differences between these people? And as you've explained, it's that different industries have different ways you can resolve these, and then the option of litigation is also part of that. And I think maybe on a more, I don't know if I think maybe if you're in practice, you can understand, because, and maybe if you're like a contractor and all of that stuff, you'll probably understand all those different avenues. But I always find that people always think when they have a problem, the first thing is, I want to sue this person, I want to take them to court. And then, how often do we just really talk to people about the other avenues that are available, the other ways to resolve their disputes? And I suppose maybe then the question is, do you think as legal practitioners we are open to all these other ways to resolve dispute resolution, and do we really sell them to our clients? And maybe is there a better way that we could be selling all the different dispute resolution methods to our clients?
You know what, I've found that when it comes to legal disputes, more often than not, your learned colleague does not want to be fighting with you. So you realize that even when you are in the throes of a litigious process, I always say to our clients, when we're advising them about the processes that we're going to undertake and how to resolve the dispute, that at every single stage of a litigious process, even before the litigious process, there's an opportunity for the parties to be able to find each other. There's an opportunity for us to, as either separately as legal representatives, meet and see if we can find, each other, having obtained instructions, or alternatively, have meetings with respective clients there. So, but even before you go to court, there's an opportunity to find each other as parties. As soon as you launch, there's also that opportunity. After you launch, there's also that opportunity. Even before you have a date where the matter is being heard, there is still an opportunity. Even on the date that the matter is heard, I know that our courts are very averse to parties, settling matters on the steps of court, but it happens more than people would like to accept. Even then, when the day we're starting a trial where parties can find each other, even in the trial, parties can find each other. Where you can't find each other is now when the matter has been finalized and we're waiting for a judgment from the judge. There you cannot find each other. But I found that, attorneys are very courteous towards each other, very collegial. And more often than not, there's always attempts, and it's not even just from me. I found that, in practice, even when you have a matter where you are not, maybe you are acting for the applicant, or the party that is initiating the action or the application, or you are on the other end, you are the respondent party, or representing now the defendant party. There will always be a reaching out from the other legal representatives that represent the other parties in the dispute. And that's because once you receive an application, for example, you conduct an analysis of the what facts weigh in favor of your clients and what facts don't weigh in favor of your client. And what are the the loopholes, or not even the loopholes, what are the gaps or potential risks in your client's claim? Will they succeed? Will they not succeed? If they defend it, will they succeed? Will they not succeed? And the same goes for an opposition. But I found that lawyers are very open to exploring avenues for negotiations and then discussions around settlement outside of a litigious process. And this even relates to processes that relates to to adjudication, to mediation, to arbitration, because I know that by the time you receive a notification of an arbitration, for example, usually more often than not, there have been attempts where, for example, the parties are unrepresented. There have been attempts by the parties of their own volition to try and resolve the dispute, and they have failed. Sometimes when attorneys come in, they're able to then cause the parties to find each other. Sometimes we exacerbate, the problem. Sometimes we worsen the problem. But more often than not, because you have a colleague and you are able to, in your respective times, conduct your own assessments of the advantages and disadvantages, even the prospects of success in a certain matter, you find that there is a very deliberate attempt these days to sell and to sell these dispute resolution processes to clients, and lawyers are open to them because now we have rules in terms of in the magistrates court and even in the high court that force us to do things like mediation. So you're not force. I'm not sure if force is the right word, because you have an option to say whether or not the matter can be referred to mediation, but it is always best to attempt to mediate, because what that demonstrates to a judge that must certify your matter trial ready, for example, and even at the end of that process, the trial judge, it demonstrates your willingness as a party to to settle the matter, and it also demonstrates your good faith and your goodwill. Because what we then do, we cut, the court rules are they're full, and it takes a very long time in our courts before you can get, not that it takes a long time to get a hearing date, but it is a while before you will be allocated a hearing date. And that's because our courts are very busy. Courts are very busy. I even wish we had more, high courts, even in, we could have 2 high courts in Pretoria or 2 high courts in Johannesburg. Because I was reading, my little sister is, she's a candidate attorney, and she was talking about how, what do I call this, in Limpopo, in the Limpopo division of the High Court, for example, she says it's a very busy court, and the roles are already now even on next year. So if you want to get a hearing date for this year, it's March. The chance of you getting a hearing date for this year are slim. And that's not because the registrars are not doing their job. It's literally because our courts are dealing with a lot of matters. So if we have rules that have been introduced, and adjudication processes, adjudication, mediation, arbitration, they've introduced mediation now in the magistrates court and in the high courts, that can then essentially have the effect of even possibly cutting the need for a matter to be allocated a hearing date on the roll, because it's been settled. We can just have processes where, how you have the separate role for, for settlements. You can just have matters where you have full settlements. But, I can say that, as attorneys, there is a deliberate trying. and you've seen it in the way that, because, you know, sometimes you approach a matter and you know you're going to lose. I mean, you know you're going to lose. In that instance, I mean, and it's not because, you know, sometimes the facts are not on your side. Sometimes the facts are just not on your side and it's not worth it. And you are then able to properly advise your client. But it's part and parcel of the process of being an attorney as well, because we have to, you know, sell these options to our clients. And obviously, you're a creature of instruction. You can't force them to accept, you know, to go to mediation. But what it does is, if, you know, because we're always speaking from an angle of, you know, I'm an attorney, you've, you know, appointed me to act on your behalf. You're incurring costs in my acting on your behalf. And, you know, if you have great prospects of success, we can cut this matter short now. And you, in the long run, you are saving costs. And also, but then you can then even cut this matter short. So I think even from a cost, you know, just not just outside of a, you know, prospect of success and risk perspective, outside of a cost perspective, from a cost perspective, it's also very important for us to sell those options to our clients.
No, I definitely agree. I think I'm understanding that what you're saying is the process itself has to include you, first of all, understanding these different dispute resolution processes. And almost for me sounds, from listening to you, it also sounds like you're buying into them as well. You know, the way you talk about how there's value in you not saying, you know what, hey, Lana, it's not gonna go my client's way. Let me
Yes.
let me. And so there's a buying into that. And then if you're able to buy into these different processes, you're able to sell it to your client, you know, and
exactly.
And I think a lot of the times you may feel like, I don't know, I think maybe the thing I want to say is I'm really shocked by the fact that you're saying that a lot of attorneys are quite open to, you know, like a lot of attorneys don't want to fight it through, because I suppose maybe my experience has been a lot of people are just like, nope, we're pushing. Let's rather make this difficult for each other, you know, raising all sorts of exceptions and whatnot, you know, just making the entire process more difficult. And I don't know, I just think you get to a point where I sit with myself, like, guys, if we had just given ourselves the moment to sit down and talk, we would have saved costs, we'd have saved each other the headache, we would have all just gotten along as people better, you know, we would have saved relationships. Because I think,
yes,
and what we're going back to is, we're still people, right? And when the way you're explaining the value of these processes is, it also has a lot of value in that not only does it save costs, but it also allows people to save relationships, because sometimes people don't want to actually lose that relationship. It's just that they're upset at each other, and and when you go and litigate, it doesn't really allow you to talk to each other in that manner. So yeah, I think you, for me, you're explaining really well. You're making me understand really the value and, well, what dispute resolution is, and the value of sort of considering everything else before litigating. You know, and I think it's not to say that there obviously isn't value in litigating. Sometimes you have to litigate. Sometimes you really don't have a choice, you know. And so just to, I think, just to go back to another question, it's, so how then do you decide when to litigate?
Well, usually you oftentimes you receive instructions from a client, and ordinarily what you are then, when you get the appointment letter or an instruction letter, sometimes it happens that the client has been served with papers, and they've been served with either an application or an action for the recovery of a monetary sum. And the instruction letter is, you must, defend or oppose this application, and then file all the necessary, papers ancillary to the opposition and the defense of that particular action or application. But in because of the time periods that are provided for, in our courts, you have the time to file the opposition papers and the defense, and you have the time to then file the pleadings or the affidavits. In preparing such an opposition or defense, you then have the opportunity to consider the documents that your client will, provide to you in order to, substantiate and build upon this defense or this opposition. So that is just from an opposition or defense perspective. So sometimes you get these instructions, you have to oppose, but even in having to oppose, you need to develop, the defense or the opposition. But when you are on the other end, when you're on the other end, you have to be the party that initiates. It's very important to, like I said, remember I mentioned earlier, just the nature of the relationship. It can be a relationship between, parents and their children. It can be a relationship between a husband and a wife. It can be a contractual relationship. So usually the decision to litigate depends on the nature of, for the lack of a better word, the infraction. Okay. And that can be, if we're dealing with, for example, a contract, let's say we're dealing with a contract where a party is supposed to, it's an employment contract, for example. In terms of the employment contract, the employer must pay me 75,000 Rand a month. And then there's a month where they pay me 50. Okay, I asked the employer, why you pay me 50? The second month, they pay me 25. Then we have a problem. Then we have a problem, because if you've gone to the employer, you've tried to address it with the employer, and there's nothing that has been forthcoming, and they're still insisting every month your salary just comes over. They can't, of their own volition, for example, decide to pay you a lesser salary than what you're ordinarily entitled to. So you've made attempts to, internally as an employee, in your own capacity to address it. Now you have to, if there's nothing that's forthcoming, they're not going to pay you back, or there's maybe some justification. Maybe they say, no, you didn't perform, so we just decided to, effect a salary cut. They can't do that. That's when you then decide to say, no, here, I've tried internally to address it. The employer is not forthcoming. Now I have to sue them for this money that is outstanding. But that's all. So when coming to the decision to litigate, usually when you're on the other side, and I always encourage clients to go back, try see if there's a possibility of us resolving this dispute. But if, for example, someone has been dismissed, there's no, we have to go to the CCMA. There's no, we have to go to the CCMA. Maybe once we're in the CCMA, there'll be an opportunity for the parties to talk during the process of conciliation. But it usually just depends on, you have to consider the nature of the relationship between the parties. You have to consider the genesis, the underlying, agreement that involves that relationship. And you then have to look at, okay, what is it's based on, if it's based on a contract, for example, but what is the particular provision that has been breached in that particular contract by way of example. So once you have that process, but then you then also need to consider, you have to consider documents that have been exchanged between the parties. So if for example, I want maybe a party owes the other party 5 million, and there've been attempts to recover this 5 million, and there's maybe emails that show that they paid 4 million, but what is actually owed is 1 million. I can't go and sue for 5. So you have to then consider all the documents that are relevant in order to prepare, the necessary papers for us to, institute the action or the application. But then you also then need to consider the defects, the potential defects in whatever claim you're going to be instituting, regardless of whether it's an application or whether it's an action when you're looking for money, when you're looking to recover money, because you have to, essentially anticipate as an attorney what the potential, you're not a genie, you're not a genie, so you can't exactly, determine what the exact defense or the opposition of the other party will be. But you should be able to, based on the documents that have been provided to you by a client, and even in the document provision process, you need to interrogate those documents. The client gives you a particular document and you can tell that, here, there might be a snag that we will hit with this particular action application that we're launching. It's very important to then interrogate those documents as well. So you shouldn't be afraid of asking your client, you know, respectfully for further documents or further expansion in relation to certain issues, because those are the things that parties raise in hearings, because someone might just rely on an email. I mean, can be someone saying, for example, I don't owe you R1, and then there's an email where that person admits that I do owe you R1. I do owe you R1. And then they're gonna say, but I said I don't owe you, or I did say I owe you. And those are the small things that, you know, come up in matters. Those are the small things that you come up, an odd email, or whether there's, you know, there was an admission or concession that was made. So you need to then also anticipate, okay, what gaps, what disadvantages are there to my client's case? And then even with those gaps, you know, you need to then anticipate how will we deal with those gaps when they do arise, because you need to be able to preempt them. You don't need to address them in your papers, you know, to say, you don't need to address them in your papers to say, what do you call this? This is the possible defense, but you need to be aware of them and be aware of the fact that it's something that will be raised. So by the time you're now instituting your action, you are very much alive to the totality of your client's case, not only insofar as it relates to the action application that the institution and the relief that they seek, but also then insofar as it relates to the possible, you know, defenses that might arise. And what usually helps in even, you know, guessing is a bad word, in assessing, yes, what this possible opposition or defense might be, is usually correspondence, you know, emails, letters, you know, even there's text messages. You know, I was having a discussion with my colleague today, and I said to her, you know, we live in a world where you can literally conclude an agreement by WhatsApp. You know, you can literally, you know, say, I'll sell you this fridge. And it's literally an agreement that you've concluded on WhatsApp for 10,000 on this date. You can conclude agreements by way of email, as long as you're able to demonstrate that, you know, the necessary, you know, essentially of a contract has been made by in terms of, you know, these particular extracts of this email. So it's very important. I always say to clients that it's just very important to have a document, you know, management process, you know, so keep, you know, a record of every single thing, whether it's if you have a telephone discussion with someone and, you know, there are undertakings that are made in the telephone discussion, record it in an email. Record it in an email and have them confirm by way of return email that this is what we agreed to. If you're able to take, you know, a WhatsApp message, you know, save those things, you know, have a record of those things, so that and have a record of every letter, every email, just everything, because you never know. Unfortunately, you never know when a dispute is going to come.
Yeah,
you never know. You can anticipate it, but, you know, you learn sometimes, you know, like sometimes someone will say, I will, you know, a party will say, you know, how parties reserve their rights and, you know, their rights to institute, you know, actions at a later stage. And then 2 years passes, and then how in year 4, yeah, you get in year 4 or in year 3, here is a whole new application, but they told you 2 years ago, you were hoping you'd receive it in the months that followed the threat.
Yeah.
But, you know, maybe now they've settled on what they want to do, and now it's year 3, and you don't want to be, you know, you want to be ready, you know, ever ready, like a battery, like the battery, right? Yeah. So it's just you know, so it's a very total assessment. And I think, you know, as attorneys, you do it without even knowing. You do this assessment without even knowing, because, you know, you consult, you know how you consult with a client, and then after you've done the initial consult, maybe a matter starts from an initial consultation, and then you have the first consultation. After the consultation, you then, you know, sending out a letter where you request documents, you consider them. You then request further documents. If you need to have further consultations, you have them. And sometimes it happens by the time you are instituting an application, it's been months of, you know, consultations, you know, verifying, you know, allegations, making sure that this is correct, making sure that nothing is missing. And I think you just do it. It's so, I don't know what the word I'm looking for is. You do it automatically without thinking, because, you know, as an attorney, you dream about your matters even. It's a very weird thing. You You have a bright spark, idea at the most random time. At the most random time, you will remember, you'll think about, you'll read a document, you'll be like, but there's something I am missing. And you'll sleep on it, and you'll sleep on it, and you'll ponder, and then it'll hit you 48 hours later, this is what you were missing. And so you even do it, unknowingly, whilst you're making coffee, whilst you're having breakfast in the morning. So it's just I think it's specific traits, but I think I've realized in life that it's a very valuable trait, because you are able to see the world differently as well. You're able to assess things differently, you're able to advise clients differently, and you're able to then draw on not just your experience as a professional, but then draw on the experiences of other professionals as well that have represented, clients in different cases that you read. So you have that opportunity to always be, saying, how can I approach this matter differently? What step did a particular, colleague follow or law firm follow in a particular matter that then assisted them in, resolving this particular dispute, or then finding a favorable outcome for their client. So it's just that approach that I think assists all of us.
I think, I feel like you just taught me how to be a better attorney. Thank you. Thank you.
We really learn from each other. It's a thing you tend to take for granted. It's a thing you take, because when you're a junior attorney, for example, working, when you're a junior attorney, for example, working with a senior counsel or another junior counsel, or even the opponent, what the opponent attorney, your learned colleague on the other side is, and has been practicing for many years, you're able to, draw, just because of the way in which they're managing the litigation, or they're managing, the approach to the matter, you're able to then draw from, everyone's experience. You're not just learning from, the legal representatives and the counsel on brief that you're working with. You're learning from the counsel on brief for the other parties as well. You're learning from your other colleagues as well. And those approaches then are able to carry you. Because you sometimes it's not all the time that you will know everything you're alive to the rule book, the time periods, but you wouldn't have dealt with every single thing related to the rule book by the time you are in year 3, year 4, or even year 5, even year 7 as an attorney. Sometimes you will encounter something for the first time in your career, in year 6. And you're then able to draw from that experience in year 6. Now suddenly you have a matter later on in year 6 where you encounter that same thing again. You're like, oh, when we were dealing with that previous matter, this is what the other counsel, or this is what our counsel did, or this is what we did, or this is what the other attorneys did. And then you're then able to then, deal with it in that same way. But you tweak it then to, suit your client's case or matter, or particular dispute. But I think it's just it's a privilege, and I always say it's a privilege and an honor to, we're sparring, but we're not really sparring, because we are essentially on the same team, and essentially on the same team in the fact that we just everyone wants a dispute to be resolved, and everyone wants, a win-win for our clients. Sometimes there will be a losing party. It's okay. We've all learned, we are all able to draw from that particular dispute, but we will fight till the death. No one will really die.
No, I think it's really important. And also, so Thokwadi, for you, when you were explaining, now you kept mentioning a lot action and motion proceedings. Can you just explain, for the listener, what exactly you mean by an action proceeding and a motion proceeding, and just explain the differences between those two?
Okay, so an action proceeding is essentially, we want money. We're claiming, so you have a party. I think just the references, in an action proceeding, you have, a plaintiff that is instituting a claim against a defendant or defendants. And in terms of that particular action, they are claiming a particular, sum of money.
Yeah.
And that particular sum of money, they're also claiming the, any interest that may have accrued on that money that is due and payable to them. You're then also claiming, the ordinary legal costs and any other further alternative relief that the court may provide. But I think one of the principal differences between actions and, even motion or applications is the particular, documents that are used to launch them. So for an action proceeding, you usually have a combined summons. And then sometimes if it's based on, there's a provisional sentence summons, that's for, a liquidated sum. So a liquidated sum would be a sum or amount that is capable of, easy, ascertainment. So you can have, for example, you'll have, for example, a matter where there's a certified, statement or certificate that says that this is the amount that is due and payable. And that is sufficient for the purposes of a provisional sentence summons, capable of easy. And so we don't need to, be fighting about the quantum. We don't need to be fighting about how it was calculated. It's been certified, it's due and it's payable. So that's for action proceedings. It's usually, for breaches, you have a breach of contract, for example, or for example, you are doing a delictual damage where you have suffered, maybe emotional harm, you've suffered, you've gotten a personal injury, maybe you slipped and, dislocated your disc at the mall, and then you had to go to the hospital and you incurred expenses, and now you have, lifelong injuries where you can't walk, or maybe, you can walk, but it's, it's detrimental. There's been a detrimental effect on your ability to, sit for long periods of time, or, even stand for long periods of time. You're then able to then claim, the delictual damage arising from your slipping and falling. And then you even have things like, the, ref matters. Those are then under, action claims. And then you then even have, what do I call this? But I think the principal difference, before I go on and address motion proceedings, is the fact that those particular, an action proceeding goes to a trial. So once you've instituted the papers, once you've instituted the action by way of simple or combined summons or provisional sentence summons, you then have the other party filing, the what do I call this? What's this?
Notice of intention to defend.
Yes, the notice of intention to defend. And then also then filing, if they have a counterclaim, they can file a plea with or without a counterclaim, an exception, a strikeout. If they file a plea, then you are then obliged to then file, a replication. And then you have a whole process, the trial readiness process, because the parties then have to discover the documents that they want to rely on at the trial. You guys have to determine whether or not you're going to use the, the evidence of experts in the trial. But then you have a full-blown trial where the parties will then have the opportunity to, to relay, oral, to testify orally before a presiding judge. And then but the purpose of this oral testimony is just to then prove, the allegations that you've made in in the particulars of claim to your combined summons. And you then also have to, provide the court through the discovery process with the documentary evidence that you're going to rely on. So it's usually what we see on TV when we are watching Suits and Boston Legal. And you have people saying, Your Honor, and they're sitting in the box, and you have inspectors. But I think I really enjoyed Boston Legal. I don't think there's been a legal show like Boston Legal again.
Haven't watched it, but
you should definitely watch it. But it's what we usually see on TV, and the performance and the rah rah rah. And I think there's a show that does. I think the show that does not justice, but that does very riveting court proceedings is The River. It's fascinating. I think when Madlabantu was on trial and she was performing, I was like, I don't think the judge would allow this, but okay, let's run with it. But it's usually the rah 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 and the hoorah that we see on TV, and attorneys are like, that's not how it works. That's not how it works, and it's not a lie. But then on the other hand, you have and then after the parties have led, then oral evidence, you then have a judge, assess the testimony of the witnesses, people that are there as witnesses, the experts, the expert witnesses. A judge will then assess the oral testimony, assess the evidence, determine whether or not a party has proved the allegations that they've made either in the, either in the statement, either the plaintiff, or if the, if a defendant has succeeded in their defense, in the allegations they've made in their defense, the judge will then weigh up the evidence laid. But I think what's very interesting about, action proceedings is that, a judge is required to test the veracity of, the evidence that has been laid. And, things like your credibility, as a witness matters. The judge has to make assess, are you a credible witness? Because you testifying under oath, so it's a very big thing. That's why it's a very, bad, it's not a good thing to lie under oath. And if you are caught in a lie, I think maybe even just the oral testimony process, because there's two parties, essentially, most of the time, more often than not, there's two parties. But, when you're testifying, just for, people at home, you're testifying, you have, your attorney or the legal representative, leading evidence that evidence in chief. So you have examination in chief, but then the other opponent's attorney also then has the opportunity to cross-examine you on the evidence that you have laid. And I think it's usually during cross-examination where you see the, the explosives. Yeah. Yeah, it's explosive. It's explosive. And if you're caught in a lie, feel bad for you, son. Caught in a lie, it's not good. It's not good. And I know that we then have the re-examination process where now, we clarify, we seek to essentially, correct any issues that may have been, raised during the examination in chief. During the cross-examination process. And this, I think, what people don't realize is what's good for the cat. One they say in English, what's good for the geese is good for the gander. Is that what they say? Yes. It's good for the goose. Yes. So essentially, it's a. I get the opportunity as a party. You get the opportunity as a party. And I think that just points to the fairness, of the law. Lady Justice has scales. So everyone has rights, everyone has the opportunity, and the courts must, as far as possible, the courts are, independent umpires. They are referees, in a match that's been played by two parties. But there are rules that are in place for, to decide upon the, the match and how these parties are even playing the game, which is very important. Yes. Then you have motion, proceedings. So in a motion proceeding, you can have, so in a motion proceeding, you do it by way of a notice of motion. And it can either be in the long form or in the short form. Short form motion of proceedings are for ex parte applications. So an ex parte application will be an application that is instituted by one party. You don't bring notification to, the other party, but then you then have, an opportunity for that, if there is a party that must be served with those papers or the party that has an interest in that matter, you then have the opportunity to have them hear attend to the matter and be part of the matter at a later stage. Then the court will issue, for example, a rule nisi in that regard, then give them the opportunity to participate in the process. But a long form, you will have, as you call an applicant when you're instituting, you'll have respondent parties that you're instituting against. So I think what distinguishes action procedures and motion procedures is that in an action, there is more often than not, there is always a dispute of fact. So you can anticipate that the other party is going to raise, allegations that will dispute, whatever allegations you have made in your papers as a plaintiff. There's always a dispute of fact, and then the court is then the umpire that must determine these disputes of fact, because now we need to determine who's telling the truth and who's not. There's always has to be someone who tells the truth and someone who doesn't tell the truth. And I think that's the marker. But with motion proceedings, there isn't, the disputes of facts necessarily. And more often than not, where there is, material, where there are disputes of fact, we always raise a preliminary point that, no, there are disputes of fact here. This matter must be referred to a trial. But in a motion proceeding, an application proceeding, you're really seeking relief outside of what do you call this? Outside of money. So you want a party to do something, or you want a party to to stop doing something. So either maybe let's say if there's a decision that has been made by, you know, a public body, the government, you know, maybe a government department has made a decision that you don't agree with and you have an interest in it because maybe you're a party that, you know, submitted a tender and you didn't win and you think there's, you know, grounds, you know, for that decision to not appoint you to be reviewed and set aside, you then go. So that's the relief you want. You want, you know, the court to come in and enter, you know, the arena and then rule in your favor. So essentially it's, you know, relief outside of, you know, monetary compensation. I've found, you know, in practice that sometimes attorneys do launch, you know, applications. So sometimes you'll have an application, you're doing it on a motion basis, but because of the nature of the relief that you want in the motion, it invites the monetary compensation anyway.
Oh, okay.
So, for example, this can be in the form of like an eviction application. So in an eviction application, you want someone to be evicted from a property and to vacate it. And then sometimes you have an example when not only is this person being evicted, but they're being evicted because they were breaching the lease agreement because they weren't paying rent. So by virtue of the fact that now we are seeking an eviction, it follows that now we must recoup, you know, all the arrear rental income and all those other costs that we, you know, that the tenant was not paying to the lessor. So that's just the tenet of what we call this opposed motion hearings. And then so you have a process where you are now, but it's also what's interesting about opposed motions is that contrary to, you know, a particulars of claim to a combined summons in an action proceeding, you have what supports a notice of motion is an affidavit. It's a founding affidavit / a supporting affidavit. And that is an affidavit that is, you know, it's done under oath. So you must, you know, you depose to it before commissioner of oaths. But I think what's very important is that you are essentially you are testifying to the facts by way of in writing, for the lack of a better word. And I think that's just a very stark difference. And that's why it's always very important to be very pedantic, you know, about detail in affidavits to make sure that if I've put in this allegation, well, people will oppose, you know, people will deny what you are saying in that paragraph. Yes. But as long as, you know, you have supporting documents, or even in the grand scheme of things, you know, the facts support what you are saying in that affidavit, it should suffice, you know, because it's still a weighing up of, you know, which version. And I think that's the important thing. You know, you have versions in the action proceedings, you have versions in the motion proceedings, but what's the stark difference in the motion proceedings is that the court has to rely on the affidavits, you know, the opposing party's affidavit, your affidavit, you know, as the applicant, and you're applying affidavit where you are responding, you know, to those allegations that have been made by the respondent in their answering, you know, affidavit / opposing papers. So, but with that is that once everyone has filed their papers, all the parties, you then have to have, you know, the matter now proceed on a hearing date before the judge. You have to then file heads of arguments. You have to file heads of arguments, and then you also then have to, you know, argue the matter before a judge. Oh, and I forgot to mention, but, you know, essentially there's still arguments in, you know, in an action proceeding. But I think they're the same. But I think because of the nature of the two proceedings, I think more often than not, people go in very hard when we are having application proceedings, because outside of, you know, the papers, unless there is a need, you know, it's very rare for a judge to say, or even for parties to even go as far as suggesting, you know, that there must be the adjudication of oral evidence, you know, in an application. I think I can say that as an attorney, you know, I'm yet to encounter that. I am yet to encounter that, and I look forward to the day when I encounter it, because it seems to be a rarity and it seems to be an exception. So that's why, you know, you must be very, you know, very pedantic about detail. Not saying that you're not pedantic about detail in the action proceedings. You still go, I mean, for the lack of a better word in slang, you say you still go as hard. And you still be pedantic about details, even when you're preparing your heads of arguments, you know, in the action proceedings. You're still very, you know, serious about your detail. And But I think the nature of application proceedings, because the judge is relying on, statements that have been made by the respective parties under oaths, it becomes very important to just be sure of the facts, be sure of the details, even things that someone would consider to be, minute, or, like a date. A date is very important. A date is very important. You can write, and I think even it can be someone writing 2022 instead of 2023. It can be someone writing 18 May instead of 22 May. So there's stark differences between the dates, and so it's just being, and I think the same process goes for action proceedings as well. You just have to be very
thorough. Just be thorough.
Very thorough. Yeah, obsessive. I think that's the word. That's the word our director likes using. Obsessive.
No, thank you, Thokwadi. Just as to pick up more, just maybe we can talk about, I think people love this thing of we're bringing an urgent application. I'm going to bring it because people think because something is urgent for them, the court is going to want to hear it and it's urgent and all of that makes it. So can you just explain what is an urgent application and what requirements you need to meet for your matter to be considered as urgent?
All right. So, urgent applications they're an exception to the norm. And they're an exception to the norm because how the courts provide for they provide for rules. As a party, when you're launching an application or an action, this is how you must launch it. And then if you're opposing or you're defending it, this is how you must defend it. And then if you want to, for example, enroll it for hearing, this is how you must enroll it. This is how you must set it down for trial. This is how you must set it down for hearing if it's an opposed motion. But essentially what an urgent application invites the courts to do, it's to essentially dispense of, the normal, the rules that provide for the manner in which we must, not effect service, but the manner in which we must, serve, the manner in which you must respond to that particular application, and the time period within which you must respond to that application, and when that application be heard. Because it essentially, what it does is it truncates time periods. So it shortens them. So where essentially, for example, in a, in an ordinary action, you would have 10 days to file a notice of intention to oppose, for example, you won't have that 10 days in an urgent application. In urgent application, an applicant will ask the judge, will specify, in the notice of motion to say, well, if you want to oppose this application, you must serve a notice of, this urgent application, you must serve your notice of intention to defend within, on or by this date. It can be 2 or 3 days, sometimes even the day after they've served you. Sometimes even the day after they've served you. And not only that, now even then the period within which you must file an opposing affidavit / answering affidavit, that is now truncated and shortened as well. So they now have to specify that, well, after so many days after you don't have the luxury of 20 days, to file, for example, if you were doing even an action, for lack of a better word, you don't have 20 days to file your plea. In a motion, you don't have the 15 days to file your answering / opposing affidavit. Now they will tell you, no, 4 days after you filed your after you file the notice of intention to oppose, you must file your answering affidavit. And then they will specify in the notice of motion as well the period within which, after they've received your answering affidavit, when they will file their replying affidavit. But then even not only is the period for the filing of the papers truncated, even then the date of the hearing is brought much more forward. Extremely forward, because the court then has an urgent role, and on that urgent role they allocate matters. But even then, everything else is truncated, because not only must you serve and file within a specific period of time, but even when you are now as attorneys, even as counsel on brief, now preparing, things like the practice notes, the heads of documents, they must be filed within a certain time in order for the matter to now proceed specifically on that particular date. So what it essentially does, it just shortens everything, and it shortens everything because of the nature of the relief that a particular party seeks. So sometimes you have, like urgent applications where someone is essentially saying, because the requirements, you have to be able to demonstrate that outside, of an urgent application, you don't have any alternative, remedy. You have to the court has to give you the relief that you seek in terms of that urgent in terms of that urgent application. Because if they don't grant you that urgent relief now, you don't have an alternative remedy. So you can't go to another court, or maybe by the time that the matter is heard on an ordinary roll, it will be moot, which means the relief will serve no purpose. The time for it to be operable will have passed. But then not only do you have to demonstrate you don't have, any alternative remedy, you have to demonstrate, irreparable harm. This is, for example, if you're seeking like an urgent interdict, you want someone to not do something or to do something, you have to demonstrate those kind of things that, you're going to suffer irreparable harm because maybe this person is, I don't know what example I can use. Maybe they, every day, maybe they like, firing their gun in the air. I don't know. Maybe they're firing their gun in.
What was the case where I think we've heard the example where if I'm married and then my husband passes, but then his family wants to come and they want to come and bury him.
Yes.
So I now go to court and say, hey, dudes, like I need to stop these people from taking my husband's body and trying to bury him in no man's land. Yeah.
Because I want to bury him in Drimanscope instead of Pretoria. Yes, that's a great example. Yes. And so now, and then you must demonstrate and I think what that example actually points to, another fact. For example, you have to demonstrate that, you have a right. There's a right that is worthy of protecting. You're a wife, you have, all the, it's not just, the privileges that are associated with being a wife, but the particular, consequences that flow from you being married to that particular individual. You as the wife should have the right to determine where your husband is going to be buried. It cannot fall to, his family or your in-laws or even your family, as the wife. So you must demonstrate, for example, you're doing an urgent interdict where you're now an urgent interdict that you have a right with protecting. Sometimes those rights are economic, maybe it can be that someone is withdrawing, funds. And I think even just the example that you gave, maybe just another example. It's like when you are married in community of property and then you want to institute, you're in the throes of a divorce proceeding, or your spouse knows that you're about to institute a divorce proceeding, but then they go and they want to withdraw money from, their pension fund. So that's when you then say, no, GEPF, I need to say, yes. That's when you say, no. Because black people, African people say, that's when you say, no. Look. You then have that, because now you want to be married in community property, you have a right to to share in that, and so it's things but I think it's like, so it's just the nature of the relief, because you have to be able to justify. And I think this is the important thing about urgent applications. It's not just about a court dispensing of the rules. You have to be able to demonstrate, court, why must you dispense of the rules for my sake? What is essentially, for the lack of I think maybe in layman's terms, what is so special about me and my matter and the facts and the circumstances that surround my, my application, that make it so necessary for me to essentially skip other people, skip other litigants, skip other matters, and be allocated a special. And essentially, it is a special, it's a very unique thing to skip other people, skip other matters, and then be sitting on a role that is unique. Why must my matter be heard next week and not, in
a year's time,
on the ordinary rule? What is so special about this matter? And that's why you must be able to demonstrate urgency. I know that you can demonstrate semi-urgency, you can, approach the court on a semi-urgent basis, where you're able to demonstrate that because people, usually you have matters that are struck down, in the urgent court for lack of urgency. They then go on the ordinary rule, and it will be, a year or so before you can, once everyone has filed their papers, it will be a year or so before you can be allocated a hearing date after you've applied for it. But now you have the benefit of you get to skip the queue. You get to skip the queue essentially, and you get the privilege of having your matter heard, by a judge in circumstances where they're not supposed to hear it because there are, other time periods that are provided for in the rules. But now you have the benefit of, I can take advantage. You can take advantage of it, but you must be able to demonstrate why you are so special and why you should be allowed to take advantage of, this very unique, what do I call this very unique procedure that allows, you as a litigant to skip the queue, essentially.
Thank you so much, Thokwadi. It's been such an insightful conversation. That's why we really appreciate it. So now I'm going to give you an option. I've got 2 questions, right? So, but I'm going to give you an option to, I've got 3 questions in it, but then the 2, I'm going to give you an option to either answer. One for the sort of, let's say, the people of South Africa, right? That question will be for the people of South Africa. The other one will be specifically for legal practitioners. So pick which one you would want to answer.
I think for the people of South Africa.
So what do you, it's actually not even a question. What do you want to say to the people of South Africa who may be feeling a little bit weary, a little bit like the justice system is not for us, legal practitioners are not for us? What would you say to them, or what do you want to say to them?
You mentioned earlier when you were introducing me that I went to the University of Johannesburg. And I think, maybe let me go back. The first time, I encountered, a legal professional was my cousin. I have a cousin, on my dad's side of the family, who is like a lawyer advocate. And as a young child, she was, as a young child, I looked up to her a lot and I admired her a lot. And we used to go to my aunt's house in Venda in Thoyando. And she was young, she was vibrant, and she studied the law, but also I think the first time she was my first introduction to a lawyer. But that also then goes for my uncle on my mom's side of the family. So that would be my mother's, brother-in-law, and he's an advocate. So I had, as a child, an exposure to the best of both worlds, because my uncle was an attorney for many years before he became an advocate. But what I saw about the legal professionals that I encountered in my family was that they were very much actively involved in developing the communities around them. So my uncle, for example, he comes from a royal household. So he was not just a leader in the home and not just a leader in the workplace, but he was a leader in the community. He was a leader in the community, and outside of his royal duties, he served his clients, but he made sure that he served his his constituents in the community as well. And he was very much a church person. But what I've seen from lawyers that I've encountered, and it's not just them, but because I was exposed to them, I had the privilege of being exposed to other legal professionals as well. But what I saw was that there was a dedication to nation building. There was a dedication to bettering, my uncle, he was in a church, and he made sure that he served on the leadership. He made sure that he actively participated. Whatever event that they had, he was there. And the same goes for, my cousin on my dad's side of the family. She was like a radio presenter. She, played tennis, participated in tournaments. So, outside of just being students or outside of just being people who practice the law, they made sure that, wherever they went, people were the better for it. They served in their communities. They participated in leadership structures in their communities. And I think that's what I have seen and encountered from lawyers, that, there's a very deliberate, attempt to go out and better, not just themselves and their families, but to make sure that other people get to, benefit from their expertise as lawyers. Because it's no good if I'm a lawyer and I cannot assist, my community, I cannot assist people that are within my immediate surroundings. But when I went to UJ, and it was just a very interesting thing, because when you decide as a teenager that you have careers day, and you're like, no, I'm going to be there, asking you, what do you want to be? You're like, I want to be a lawyer. And then you're there participating in debating when there's best speakers, and you are you excel in languages, and it's just those, you read a lot, you consume a lot, but you're set in the fact that you want to be an attorney. And it's not because of what you've seen on TV. It's because you have seen, and not to down the other professions in our our parents are teachers and educators and nurses. You learn in the home as well. But also that worldview to become an attorney is also informed by the type of attorneys that you see in your immediate surroundings. They make you want to become attorneys because it's not about them. When I went to UJ, we had as part of our I did my BCom law first, but as part of our LLB module, we had a module called Introduction to Litigation Techniques. And as part, it was a final year module. And as part of that module, we had to serve, they allocated us. So every single final year law student, so UJ has 3 campuses. There was Doornfontein, there was the Soweto campus, and then there was Kingsway. Yeah. And then what they did was they allocated, so amongst the entire, LLB year group, every single one of us had to go and do essentially community service within a law clinic. So there were 3 law clinics across the campuses, and you had to then go and do community service within a law clinic. So even before you are jumping into the working world, I know that people did VAC work and stuff, during, the LLB studies and the undergrads. But on a practical level, you were required to now go into, for the Doornfontein constituents, for the, the Kingsway campus constituents, for the Soweto campus constituents, you were required to now go, and serve, that particular community. So you were essentially a student legal advisor. You were preparing papers, working under the tutelage of a principal. I'll never forget my principal, Alleged Bail. And there's also, I forget the name of the other colored, the other Gwesan instructor. I think it was Mr. Hart. I stand to be corrected. But, we were required to, on a certain day, you'd be stationed at, the law clinic for the whole day. And you're not just stationed there for the sake of being stationed there. You're consulting with clients. You are preparing, pleadings and affidavits and notices that are being then reviewed, by your principal for mock purposes. And then more often times than not, a lot of us, we were required to, if I remember correctly, I think we were required to do a minimum of 80 hours throughout the semester, because it was a 6-month thing throughout the semester. But a lot of us far exceeded that 80 hours. And I think that was just because you not only saw, the fact that, I think given the nature of the matters that we were exposed to, you were reminded of the fact that everyone should, have the privilege of, having access to legal services. And you were reminded of the fact that it's not a, legal services are expensive, but it's not a niche, for the lack of a better word, or a category that is, specifically reserved for people that can afford it. And I mean, because we used to do means tests in order to qualify, the individuals that were, given these services, but you were grassroots level. You had to deal with people's problems. Your principals expected you to interrogate and, prepare. So even if you're preparing a pleading, you don't prepare it just because, Mrs. Bale is going to review it and then it will be fine. I remember Mrs. Bale would do this thing with us where she would sit with you and give you feedback on the document that you had prepared. And even our instructor for, Introduction to Legal Studies, it's times where, the principals would not be, available at the at the law clinics across the campuses, he would then sit in for them. And, you know, we'd have processes where they go through the papers that you've prepared with you. And you are then able to discuss even the matter and the consultation, and you sit in on consultations. And I think what I was able to see was that our principals had a passion and a heart for people. And you know, the matters where you jumped in, you know, you're only going to be sitting on this matter for dealing with this matter for 6 months, but your principal would be, because you have the file and you go through it, and even when your discussions, your principal would be able to tell you, you know, this case is very close to my heart. I started with it on this date. Then you'd have the privilege of sometimes going to hearings with them, you know, so, and, you know, filing things. And I think I was able to see that, you know, you learn collegiality. I learned a lot, you know, I think I got to know a lot of my colleagues, even colleagues that I hadn't encountered during the many years of my studies then. And, you know, I've been able to carry those connections. But I also realized that it's very important for us to have access. And I think now what we're seeing in South Africa, not only do we have, you know, multiple law clinics that are, you know, conducted and, you know, facilitated and run through, you know, like, you know, UJ and various universities across the country, but you also have the introduction of, I know that people don't like to speak about these things. They think it's like, you know, but you also have the introduction of, there are people that don't meet means tests to qualify for, you know, pro bono legal services, law clinic, because they are middle class or middle income earning people. Those are people that would then, you know, be provided legal services through your Scorpion and through, you know, it's not, is this free advertising? It's not free advertising, but through, you know, through entities like that. And I think you're seeing, it's not just Scorpion. There's a lot of entities that are now recognizing, you know, the need for people, you know, because we have categories in South Africa, unfortunately. Yes. Our income, you know, our income spreading, you know, our income inequality is wide. So you do need to curate, you know, services for particular, you know, income brackets and particular niches. And outside of that, you're seeing a lot of, and I think even the way that some, you know, industries, particularly when it comes to, for example, RAF matters, where they're done on a contingency basis. Because in a normal setting, someone who has, you know, been injured, you know, has you know, suffered a personal injury, they're not going to be able to afford to pay a radiologist or a specialist to conduct exams. But you as a law firm are able to step in, assist them, and then recover your cost on a contingency basis. So I do think, you know, there's a lot that we still have to do. But there is a long way that we have come as a country in, you know, trying our best to make, you know, legal services affordable, and not only that, accessible. And I think you see with a lot of law firms now, there's, you know, I think there's even an increasing popularity of, you know, because we're required to do pro bono matters anyway by the LPC. But outside of doing, you know, the mandatory requirements of the LPC, what then also becomes important when you see, you know, with a lot of law firms, they have pro bono departments where they render, you know, legal services to the public for free. So I do want to say to the majority of South Africans not to be disheartened. You know, it takes a while for, not a revolution, but change takes time. But I think we are moving towards, you know, making, legal services accessible. I do think there must just be a move to make them more accessible, particularly given, you know, this income, you know, inequality that is very, you know, that is widening, you know, and that is very wide in our society. So it becomes very important, I think, even because, you know, you can't give free legal advice to, you know, to people that you just meet. You're not allowed to do that. It's not responsible. But you can refer people, and I think I've seen this with a lot of, you know, law firms. We refer, you know, if a client comes to me and, you know, you consult with them for the first time and you realize that, no, this litigation is going to be very expensive, or this matter is going to be expensive, I know, you know, a colleague that can do it for, you know, for at a much lower rate, or at a very substantially reduced cost, and you refer them to a particular law firm. And, you know, law firms have that relationship, because it doesn't assist a particular individual to come here, to a particular, you know, member of the public to come to you. You're unable to assist them, and your thing is just, oh, I'm expensive. But refer them to someone who isn't. Refer them to a colleague that doesn't charge, you know, doesn't charge the fees that you charge, but will be able to assist them and give them the necessary assistance. And I think what I've seen is, even as, you know, attorneys, you're able to negotiate. And I think I've seen now, even, you know, internally, for example, you're able to negotiate, you know, your rates with your clients. And if you're serving, there's a very big, you know, with corporate clients, you'll have SLAs and you must charge in terms of this SLA. But with individual clients, because you understand the, you know, you understand income, and you understand how, you know, if a particular
backgrounds and
yes, if you know, for example, that, I don't know what example I can give. You know that your client is earning 12,000 Rand a month after tax, for example. You're not going to charge your client 12,000 on the invoice for that month. So it's just things you think about as a collective. I mean, we were having, maybe I'm giving you secrets, but we actually, you know, we're having, and I think it's just, but I think it speaks to the wider trend across a lot law firms. I'm not sitting in internal meetings, but we have noticed, you know, the trends. And I remember internally we were having a discussion about, you know, how the approach should be to individual clients, because we serve private individual clients, private corporate clients, but you also then want to, you know, give the same service to your, you know, private, you know, individual clients, to individual clients. But then how do we serve them in a way that is financially sustainable for them, and then also financially sustainable for us as a firm? So to a point where you can dedicate the necessary resources and time to the matter without compromising on quality as an attorney. And what would that sum look like? Because it wouldn't look like, for example, you charging the normal rate that you would an international entity, for example. But how do we then, you know, bridge that gap as a law firm? But it's just ongoing. You know, you just have these discussions amongst each other as colleagues. You have these discussions, you know, even with, you know, colleagues that operate within, you know, as a law firm with you in the same sphere. To say, okay, what are you guys doing? Because we are competitors, but it's always good, you know, to see what other law firms are doing differently, and how we can, you know, build upon it or improve upon it. Or even, you know, if one law firm is like, you know, so it has like a particular, you know, fee rate for individual clients, it's always good to, it's private, it's their private, you know, but their intellectual property. But, you know, if you're able to then, you know, build upon any rapport that you have, you're then able to see that, oh, maybe this is something that we can look to do as well. So there is hope. There is hope. And I think our judiciary is very much alive. You know, you see it when you read judgments that, you know, judges recognize, you know, the difference between a big corporate entity that has financial muscle and can muscle through a matter all the way from the High Court all the way to the Constitutional Court, an individual that doesn't have the necessary financial muscle to do that from the High Court to the Constitutional Court. But along the way, there is always an option. Along the way, there's an attorney that is willing to do the matter on a contingency basis. Along the way, there's an attorney that is not charging the usual rate for the matter. So I think the idea is for people to not be afraid of approaching law firms. Don't be afraid of approaching a law firm for assistance. Don't be afraid of having that initial first consultation. Don't be afraid. And the thing is, I always say to someone that the worst thing that a law firm, that a representative at a law firm, or even the director of the firm can say is no.
Yeah.
The worst thing they can say is no. So if you know, you gather the funds for a first consultation, you have a first consultation and you want them to assist you, and then maybe you want a particular individual to assist you. I mean, we have a thing, for example, at our law firm where we conduct an assessment upon as professionals, and we, you know, it's not that you say it's not that you're weighing the purse of your client, but you are taking their needs into account. You are taking their needs into account. And that's when you then, for example, have one professional working on a matter instead of two.
Okay.
Four. So that's what I'm saying, that there's nothing wrong with approaching a law firm. The worst thing that anyone can say, or any law firm can say, is no. Even if you say you want the director to do your matter for a reduced rate, or he can say, no, I'm not doing that, but I'm willing to, exercise oversight on it. For example, I'm willing to exercise oversight on this matter, and then I will have one of our junior, associates or our, candidate attorneys work on the matter for you at a reduced rate to save you cost in the long run. So there's solutions. And I think now we're even seeing, outside of, contingency things and reduced rates, now people want to fund litigation. You have
yes, I've seen that.
You have firms that now want to, these corporations that are coming up, and they want to fund your litigation. So I was like, people are coming up with very creative and very clever ways of opening up the discipline of, litigation, and opening up the law to people. Because it's not even just about cost, it's about language. It's about language. I think we had, for example, for the first time in the High Court, we had not the High Court, in the Labour Court, we had a judgment that was given in, was it Sesotho?
Yeah, I can't
remember. Think it was,
but I did
yes. So it's language, and that's why you have, I think it's things that we tend to take for granted, but the fact that you even have an interpreter in court.
Yeah, I think it was Sesotho. Sorry, I was just thinking about
yes. Oh yes, it was. The fact that you even have things like interpreters in court, and I think our the judiciary as a whole, even down from from court clerks and registrars, there's an extension and a latitude to accommodate laypersons, to accommodate citizens, because they all have a right to access the courts. They all have a right to justice. Everyone, we all enjoy the same rights. But where you are able to, because of the privilege and the privilege that you have, where you have much easier access than someone else, it's also obligatory for us to then make sure that where there is, a bar to that door, we then open it for other people as well. So I think just to say there's hope, and people mustn't think that I know that litigation is very expensive, but there's hope. I'm hoping that in the years to come, these other forms of financing litigation, and even entities such as Scorpion become much more, so that people have the option of choice, and we can then even do it according to the brackets. Because I was saying, for example, when you have these instances, sometimes when you are a family, or you are maybe, let's say, a teacher, to an educator, and you have to fund your own litigation, and people end up having to now take out loans to fund the litigation. You're going to recover the costs at the end of the day, if to a very substantial extent, if you win the matter. But you also want to then create solutions for those kind of people, because they can pay for Scorpion, but there's express terms and conditions, and sometimes. But then what solution can we then introduce for different? Because I've seen there's a big gap in the market, but not only is there a big gap, but there's a big opportunity for corporations to then take advantage of it, and just to come up with solutions for people. Because what I've realized is, even if the majority of South Africans are not economically active, South Africans have buying power. Have buying power. They have buying power, and I know people think about cars and houses, but we buy food. We buy clothes. We go to concerts. I mean, when Chris Brown comes, the people that go to the Chris Brown concert. So South Africans do have buying power. It's just about, I think it's just about corporations then, tapping into that buying power. And I think you've seen it, for example, what's this organization that does AfriForum, AfriForum, they do their own litigation. And I was having a discussion with one of my colleagues, and I was like, there's so many options for us as a collective. So many options for us as a collective. We have clinics, we have, justice centers. I mean, we have organizations that are just NPOs that literally litigate. They litigate to fight for the rights of, foreign nationals. They litigate to fight for the rights of ordinary citizens, to make sure that people have homes, to make sure that people have running power. And I'm like, you won't, have power. You won't hear running water and power. You won't hear about these cases a lot, you won't hear about ALS a lot unless you are like actively, looking at matters that are like coming out. But these are the bodies that are there. And I think it's just about making sure that as a nation and as people are aware of these bodies. People are aware of these bodies, that even if you're people that are being evicted and you are in an informal settlement, you still have rights. You still have rights, and you can approach the necessary body to be protected. You don't have to pay, a law firm 6 million and then struggle to gather that 6 million. But there are options. And I think it's just about us making sure that we bring, these options and, that are available to provide, citizens with access to justice, that we just bring them to their attention.
No, thank you so much. I could talk to you forever.
Yeah.
But we probably
we won't sleep.
Thank you so much, Thokwadi. I think this is both, it's insightful, it's helpful both for the legal practitioner, but also for the public, and I think that's really the kind of message we're trying to drive out as the Law and Life Matters podcast, to be able to talk to the public, but to also be able to continue to equip the legal practitioner to be able to help that same public. So thank you so much for your time. We really appreciate it. I look forward to listening to this conversation over and over again, and I'm sure that most people are going to have many nuggets to take away from it. So thank you so much. Just as a parting shot, do you have any social media pages or where you'd like people to contact you? And yeah, you can just give us those.
Okay, so I think please visit our website. It's www.mbaincorporated.co.za. So we're Mutweneng Attorneys Incorporated. So a vibrant, young, dynamic firm made up of very, astute and learned professionals. So we can be contacted on our office line is 011 463 9401. And if people need to get a hold of me, my cell phone number, or you can contact me on my work cell phone number. It's 083 564.
Sorry, please start again, babe.
It's 083
564
92 99. Okay. Yes, but I do suggest that, if people need to get a hold of us, they just contact our office line, and then we can be reached by email. I think Thokwadi@mbaincorporated.co.za, and then we can then also be reached by email on info@mbaincorporated.co.za or admin@mbaincorporated.co.za. So, but please do so if you need to get a hold of us, you can drop us an email, drop us a call. There'll definitely be a professional that will get back to you so that you get the necessary assistance that you need, as a particular individual. But I do want to say thank you so much for having me. I had a lot of fun. I had a lot of fun. I was very excited. I was very excited when I received, the invite, and I'm so glad that we were able to have this conversation. So I do look forward to having a lot more conversations with you, and other professionals as well. And I think I'm so glad. It's not every day that one gets to be invited to form part of, a podcast, especially for, an organization like SABWiL. So it's big, it's bigger than big. And, I even, said to our business development team, and I said, I was so excited. I was even asking, is it live? I had so much excitement. So I'm so glad and I'm so happy. So thank you so much for this privilege and this opportunity. It is a privilege and an opportunity that I do not take for granted, particularly, given the role that, one occupies, not only within, MBA Incorporated, but also in the world. And I think I just want people to remember, just as a parting shot, that every one of us has intrinsic value. Every one of us has intrinsic value. And, and that's just because before I'm Thokwadi, before you are saying you belong, to the Lord. You belong solely to the Lord. And so I just want people to remember that God is with them always. He'll never leave you. He'll never forsake you. He's in you and he's all around you. So even when times are tough in our country and times are tough in the world, and, we're watching, markets and financial markets and banks collapse, we need to just always remember that, God is in charge and God is in control, and he knows the beginning from the end. So we must just rest, in the promises of the Lord, and just remember that, God, Jesus is alive. Jesus is really alive. And not only is he alive, he loves each and every single one of us. So thank you so much. And I hope that you enjoy the rest of your evening. And hello to your, the viewers that will be watching this podcast later.
Thank you so much, Thokwadi. It was such a pleasure. Enjoy the rest of your evening and the rest of your week. Thank you.
Thank you, you too. Thank you so much. Bye-bye.
Bye-bye.